Hello, my name is Michele Herrmann. I'm an associate professor in building construction science at Mississippi State University, and I will be speaking about the COVID-19 vaccine mandates in the construction industry. I think we're all familiar enough with COVID-19 at this point. I will just bring up a few facts that are relative to the vaccine mandates. In terms of a global impact, COVID-19 was named a global pandemic in early 2020. All of the dates and information in the paper are as of the date the paper was submitted. I have gone ahead and updated these numbers effective May 10th, 2022. So according to the World Health Organization, as of May 10th, there have been more than 515 million confirmed cases, more than 6.2 million deaths, and more than 11.5 million vaccine doses administered. In the construction industry, in the U.S. specifically, as of April 2020, 17 states suspended construction activity with only limited exemptions for projects deemed essential, such as healthcare, infrastructure, and emergency repairs. In the remaining states, all construction was deemed essential and therefore allowed to continue. However, anywhere that construction took place, additional precautions were required. Some of those additional precautions included daily health screenings, social distancing, masks, disinfecting, and contact tracing, all of which are obviously difficult to implement on an active construction site. The timeline for the development of the COVID vaccine began when a public health emergency was declared in February of 2020. By December of 2020, the United States Food and Drug Administration issued an emergency use authorization for 2 different vaccines for those ages 16 and older. By February of the following year, a 3rd vaccine was approved under the emergency use authorization, also for those ages 16 and older. By May of 2021, vaccines started to be approved under the emergency use authorization for younger age groups, and by August of 2021, Pfizer was the first vaccine in the United States to receive full approval from the U.S. FDA for those ages 16 and older. There have continued to be additional developments related to other age groups and boosters, but that August 2021 full approval for the first vaccine for those 16 and older is important relative to the vaccine mandates. In the U.S., 2 vaccine mandates are the focus of the paper and presentation: Executive Order 14042 and the Occupational Safety and Health Administration Emergency Temporary Standard. Executive Order 14042 is the executive order on ensuring adequate COVID safety protocols for federal contractors, and it was issued in September 2021, 1 month after the full approval was obtained for that first vaccine. And it requires all employees of federal contractors or subcontractors to be fully vaccinated against COVID-19 or have a legal exemption from vaccination, and those exemption categories will be discussed later. The Occupational Safety and Health Administration Emergency Temporary Standard was announced in November of 2021. And in the United States, OSHA is responsible for ensuring U.S. employers comply with requirements intended to prevent employees from being injured or acquiring illnesses while at work. It was enacted as an emergency temporary standard, which is a temporary measure that can be used when a grave danger exists, and it allows the public comment period to follow enactment rather than precede it. And this ETS requires employers with 100 or more employees to require all employees to either be fully vaccinated or be tested weekly for COVID. And it applies whether the employer conducts business with the federal government or not. As applied to the construction industry, each company on a job site would be evaluated individually to see whether each individual company meets that 100 employee threshold. Employees who work exclusively outdoors are counted toward the number of employees, but if they work exclusively outdoors, they do not need to show proof of vaccination nor submit to weekly testing. However, that exclusively outdoors phrasing is interpreted very strictly. A brief indoor meeting, such as a toolbox talk, would disqualify the employee from being an outdoor employee. So this would be difficult for most trades to comply with. And it's not entirely clear what constitutes outdoor, whether that's once the roof is on, once the exterior walls are on, or anything prior to dry-in is not entirely clear. In the United States, vaccine mandates do have a long history. In the U.S., the Centers for Disease Control and Prevention recommends 16 vaccines between the age of birth and 18 years. It is then up to the individual states to decide which vaccines are required to attend school. All 50 states and the District of Columbia currently require at least 7 vaccines. In addition to those 7, many states require additional vaccinations. For example, 46 out of 51 states also require vaccination for hepatitis B, while 34 out of 51 also require vaccination for meningitis. To be exempt from vaccine mandates in the United States, there are 2 broad categories of exemption. The Americans with Disabilities Act requires provisions for exemptions based on medical reasons, and those provisions can vary from state to state. The Civil Rights Act of 1964 requires exemptions based on religious reasons. There have been challenges to vaccine mandates, dating back as far as 1905 in the U.S. Supreme Court of Jacobson v. Massachusetts, which is a case challenging a state requirement for vaccination against smallpox. In upholding the vaccine mandate, the court stated that while individuals are afforded great liberty under the Constitution, that liberty does have limits, and there are times in which we are subject to restraints for the common good. The court noted that the vaccine mandate in that case was adopted at a time when smallpox was prevalent in Massachusetts, and that the state had a right to protect itself against this epidemic, which threatened the safety of its members. A more recent challenge to a vaccine mandate is the 2017 case of Fallon v. Mercy Catholic Medical Center of Southeastern Pennsylvania. In that case, Fallon was denied a religious exemption from a flu vaccine. When he still refused to receive the flu vaccine, his employment was terminated, which he said constituted religious discrimination under Title VII of the Civil Rights Act of 1964. The court disagreed with him, though, and found that Fallon's objections to the vaccine, which related to concerns about side effects or effectiveness of it, were not based on religious beliefs, and therefore upheld his employer's right to terminate his employment. Some potential legal issues that arise with the 2 COVID-19 vaccine mandates. Executive Order 14042. I think the first thing to note is that entering into federal contracts is a privilege. It is not a right, and it's also not mandatory. If companies don't want to comply with federal contracting requirements, they're not obligated to partake in federal work. I think the question arises is, how does this vaccine mandate differ from any other federal contracting requirements that companies have to comply with, whether it's the long list of certifications that are required, pre-qualification requirements, or things like E-Verify. I think the issue that may come up is also, should companies be able to continue to argue that COVID-19 constitutes force majeure or an excusable delay if vaccination would help prevent or reduce those delays? If this executive order stands, employers will be required to comply and verify that their employees are vaccinated, subject to those religious and medical exemptions. Companies have already taken varying approaches to granting those religious exemptions in particular. Some companies are simply asking 1 or 2 questions, does this violate your religious beliefs? Whereas other companies are digging a little bit deeper and asking what religious beliefs specifically would prevent you from receiving this vaccine, and have you objected to any of the other required vaccines in the past? The emergency temporary standard, typically vaccine requirements are the discretion of the states. This emergency temporary standard is not a nationwide vaccine mandate. It is limited to certain employment situations. I think the question will come down to, is it related to preventing employees from acquiring illnesses at work, which is one of the objectives of OSHA. And I think it's also important to question what is the basis for that 100 or more employee threshold. If we're trying to prevent acquiring illness at work, what number of employees is a good basis for requiring that vaccine mandate. In conclusion, both of these are really to be continued. With Executive Order 14042, since it was introduced in September of 2021, 26 states have filed 7 federal cases challenging the order. 6 injunctions have been issued, one of which is nationwide, and that temporarily halts enforcement of the order. The U.S. has appealed all 6 injunctions, and those cases are pending to determine whether that order can be enforced or not. The emergency temporary standard was withdrawn by OSHA effective January 26, 2022. Now, OSHA is not abandoning some sort of COVID protocols, it's just withdrawing it as an ETS, and instead is working toward a more permanent COVID-19 healthcare standard for OSHA. Thank you for your time. If you have any questions, my contact information is listed here, and please feel free to reach out to me.